Alright, so Diesel We the People News again. Alright, so this is going to be part 2. And over the First Amendment and jury notification. Alright, this video is without prejudice and without recourse. Okay? I'm not waiving any of my rights whatsoever. To prove it, I'm going to go ahead and stand on UCC 1-308. Okay? And I'm going to go ahead and accept UCC 1-207. Alrighty. Anything I say or do is just my opinion, and my opinion only. Okay? You guys be very careful and listen to some of these words they use, right? Because when they talked about, like, for this instance, 200 feet away from the court, well, it's been pretty much established about the First Amendment to record and all that kind of stuff. So are you saying just because juries are around, you to waive your rights? Is that what they're saying? When you enter a court building, are you saying you're waiving your rights? When you enter that courtroom, is that judge saying when you enter my courtroom, you need to waive your rights? That when you walk into these doors, you no longer have any constitutional rights whatsoever? Because when they say you can't record in there, that means you don't have a First Amendment right. They're going to nitpick it and all that, but that's what they're saying. Just saying. Let's go ahead and proceed forward on this.
Would be unconstitutional.
If the statute were applied to advocacy that did not regard a specific pending trial in the nearby courthouse, the state would not defend that application.
If it did not apply, is that what you said? I'm trying to understand what you said.
If the statute were applied,
yes.
if a local prosecutor would bring a case, or someone were arrested for general advocacy outside of a courthouse relating to the justice system at large, but not regarding a specific pending trial in that courthouse, we would not defend that application of the statute. We don't think the statute applies, and at least as far as Mr. Picard, we concede that the Constitution would protect that advocacy.
Well, you wouldn't. You say you wouldn't defend it. Are you saying that wouldn't be a prosecutable case? Or if it were prosecuted, it would be unconstitutional?
We are saying both. The standing argument is the first question, the answer to the first question, and the merits argument is the answer to the second, which is why that we are seeking to defend only applications that we believe are presumptively legitimate under Supreme Court case law and are in the wheelhouse of what the statute was intended to prohibit, and that is a picketing mob outside of a courthouse within the 200-foot zone advocating a specific
Well, you load it a little when you say a mob.
We're going to stop right there. Picketing and regressing your grievance with the court building is constitutionally accepted. That's what the founding fathers said, that we must do this every 20 years. I say sooner, but every 20 years we all are supposed to actually do that. And fill the streets. And what these people are saying is you're not allowed to do it. Why? Because we have not been doing it every 20 years like we're supposed to.
A mob tends to be at least either actually or potentially disruptive. What about leave the word mob out, just a group of people, or not even a group, one person who's there urging jury nullification? Is he prosecutable under the statute?
Not if that person were urging.
Not what?
Not if that person were urging jury nullification in general, like Mr. Picard was, but if that person had a sign that said, State v. Smith, all jurors must acquit, Smith is innocent, then yes, that would be prosecutable, and the statute properly reaches that particular advocacy.
See, there we go again. That's still free speech, y'all. That is that guy's opinion. Hey, look, juries, I believe that, but he's not guilty, and this law is unjust. Is that tampering with the judge? No, it really ain't. They say it is, but it ain't. Tampering with the judge is like, hey, I'll give you $20 if you plead guilty and all that kind of stuff, or any type of threats. But saying, juries must acquit this. No, that's just free speech.
For you, the test is he urging an outcome in a case, or a general approach to what juries do?
The former, Judge Newman, and that is the language of the statute itself. The statute prohibits shouting or signage, arguing for a specified outcome in a particular pending case in the adjacent courthouse. So that, yes, would fall under the statute, and in our view would be prosecutable, and legitimately so, or at least that this court in this case doesn't need to decide that question. It's enough simply to affirm the injunction as applied to Mr. Picard's general jury nullification advocacy, if the statute arguably covered that. And that's what this court did in American Booksellers, in a case that presented, I think, a less compelling circumstance for as-applied relief. It was a statute there, a Vermont law, that directly targeted internet obscenity, and the plaintiffs there, the challengers there, were websites.
That's your view. What is it for us? Your third option was certifying to New York. What is it we would ask the New York court to do, to decide?
Definitively construe the statute and decide whether it applies to Mr. Picard's general jury nullification advocacy. Now, if it didn't, the case would be over, because the parties agree that in that case, Mr. Picard would lack Article 3 standing.
You're here saying you wouldn't prosecute that case.
Yes, but the test for pre-enforcement standing is whether the statute arguably applies, or the challenger has proffered an arguable interpretation. And if this court were to think that the statute, that Mr. Picard's advocacy arguably falls
Are you
under the
saying
statute,
on behalf of the state would not prosecute that case?
well, the state has limited prosecutorial authority, Judge Newman, but you're saying that
Whatever your reasons, are you saying the state would not prosecute that case?
the state would not prosecute Mr. Picard's case if he were, say, tomorrow.
Then why should we ask the New York Court of Appeals what they think about a case you wouldn't bring?
Well, this is just the issue. Judge Cote she construed the statute not to apply to Mr. Picard's advocacy, but under the relaxed standards for pre-enforcement First Amendment standing, proceeded to the merits. It wasn't enough that
Ms. Milton, I think, isn't your argument that you don't control most prosecutions in New York State, which are brought by district attorneys who are responsible not to the Attorney General, but to the voters of their particular county?
That is the reality of the state local division of business.
So that the fact that your office wouldn't bring such a case, your office probably couldn't bring, I'm not an expert in the vagaries of when the Attorney General could bring a case, but either it could not in the first place because it lacks the statutory authority to prosecute this kind of offense, or in any event, it would be a most unlikely scenario, and the likely scenarios involve local district attorneys and local police departments.
That's exactly right, Judge Lynch. And Judge Cote, after construing the statute in her view not to apply to the facts of this case, didn't have the luxury of certification, and this court, by contrast, does. All three certification factors are met. I believe they're undisputedly met. There's no appellate authority in New York ever construing the statute. The statute and the activity that it prescribes is of public importance. Demonstrations outside of government buildings have just dominated the current news cycle. And the parties agree that a definitive construction of the law not to apply to the general jury nullification advocacy at issue here.
If we agreed with Judge Cote about the standing issue and thought that the case was properly brought, do you care which of the other two outcomes that you're advocating for, as between those two? Do you have a preference? Does your office have a preference?
The office does not have a preference. We would be happy with either one, although we acknowledge that certification would be less economical, whereas an injunction...
Sam, think about that. They're talking about really jury nullification, actually tampering with juries. But Facebook does that all the time. All the time, y'all. public opinions do that all the time. Just because they put a guideline of 200 feet, there still is tampering out there. So why is there a 200 feet deal of tampering with juries when all across the United States is tampering with juries? Right? And then why is there a restriction on filming? Right? Because we all gone ahead and decided to waive our rights.
Function as applied to Mr. Picard's advocacy would end the case and protect the plaintiff's rights in full. The last thing I'll say about certification is that the only argument that Mr. Picard appears to make is that the statute, that certification would be futile because the statute is unconstitutional facially no matter what. Now that assumes the very conclusion that certification would seek to avoid. This court has in the past on multiple occasions certified cases certified questions to the New York Court of Appeals that would inform whether a party has standing. One of those cases in Ray World Trade Center, Judge Lynch, you were on that panel, and at a minimum, a definitive construction of this law, and the Court of Appeals could settle on an interpretation in between the poles that the parties have presented, would at minimum inform an overbreadth analysis, because this court can't intelligently determine whether a statute reaches too far unless it actually knows what the statute covers in the first instance.
Thank you, counsel. You're reserved 2 minutes for rebuttal. Mr. House?
Flashpoint Live returns to the Fort Worth Convention Center Sunday, July 31st at 6 p.m. Central. Join Gene Bailey, his guest.
2 minutes for rebuttal. Mr. House?
May it please the court. My name is Brian House, and I represent appellee Michael Picard. I'd like to start with something that the parties agree on. The act makes it a crime to carry a sign protesting a prosecution outside of a courthouse on the public street, even if there is no intent to influence a judge or jury, and even if there is no danger that it will interfere with the administration of justice.
Mr. House, could I ask this?
Okay, sit and think about that, right? The courts are supposed to go by actually intents, not presumptions. By facts, not presumptions. Okay? So when he's doing this, he wasn't trying to sway the jury and all this kind of stuff. But they're saying that because he accidentally swayed the judge, that made it illegal. And the statutes are saying we don't even want you to do something accidentally.
Simpler question. I understand perfectly well why Mr. Picard wants to bring this case, and I understand the argument that you make and that Judge Code adopted for why he has standing to do so. I'm having a little bit more trouble understanding why you are still here after this argument from Mr. Del Pozo, because as far as I can see, he has conceded that an injunction that protects the only advocacy that Mr. Picard has ever engaged in or expressed any desire to engage in, anything that he has done or that he says he's ever going to do, is A, in their view, not even against the statute, but B, is constitutionally protected. And essentially, he's assented to an injunction that protects Mr. Picard in everything he wants to do. So what's his beef with whether, and why should we be deciding whether a howling mob standing outside the courthouse right across the street is saying either hang a given defendant who's on trial inside or free him and hang the judge and jurors who might convict him? Why do we have to decide whether it's constitutional for New York State to have a statute that would prohibit that? Why does Mr. Picard care? Why should we have to address that at this point on these facts?
Well, Your Honor, it's going to be true in every case, in every facial First Amendment challenge, that an as-applied injunction would protect the individual plaintiff's rights. But in a facial First Amendment challenge, the Supreme Court has said that this court also has to consider the First Amendment rights of other members of the public, and that's
Yeah, but and you say we're going to have to face this eventually, right?
that's right, Your Honor.
We haven't had to face it in 50 years. In fact, almost no one has ever been prosecuted for violating this statute. Very few.
Okay, and he's going to say very few, but I challenge that even, all right? They haven't been prosecuted maybe in 50 years. People has been going to jail. That is actually an issue. Whether they've been prosecuted or not, they still spend a night or a weekend or a week in jail because they had no bond just to have the case dismissed. So there's been 50 years of people going to jail under the statute and not being prosecuted. Something to think about that, y'all. The officer's been judge, jury, the executioner, just to be denied due process in court because the prosecutors decide not to press forward. Let's pause here and go to the next one, y'all. All right, this will be the People News. Bye, y'all.